Okay. So thank you very much for being here.
Can I have some water?
We go on. Like this morning was particularly fun and interesting because it's the third panel in the same room on similar topics. So it's like a long line that we develop under different perspectives. And this is the last panel before lunch, so I know that we have to be like more attractive than others. And it's also Friday. So we're gonna talk about health data and artificial intelligence in clinics and research, legal basis. I changed I with E because, as we just discussed a few minutes ago, it's not just one legal basis, but more legal basis for research and health data processing, transparency and accountability. This panel is I'm Gianclaudio Malgieri from Free University of Brussels, and this panel is co-organized by Brussels Privacy Hub and PANELFIT project. Is just 2 words about the project. Where does it go? Yeah. PANELFIT is a Horizon 2020 project dealing with changes in the regulation of ICT research and innovation. It will release legal and ethical guidelines for stakeholders, building on 3 pillars: informed consent and automated decision making, data commercialization, and cybersecurity. And these guidelines will serve as operational standards, able to reduce the ethical and legal issues posed to ICT technology research for SMEs, universities, entities, etc. It's a group of 13 entities, and I see among you some of the entities represented in this co-creation project. Among this topic, we are analyzing. We decided just to focus on health data to delineate better our scope. So these are some of the questions that we are dealing with. And then Albena will explain better this. So in particular, how to balance public interest and private interest in that. The different conflicts should be solved and addressed, and in particular how GDPR tools can effectively help in terms of fairness, accountability, and transparency. We have here a great set of panelists. Thank you all for being here. So we have Albena Kuyumdzhieva from the European Commission, and she's our point of reference for this project and for other projects in the field. So we are very happy to have her view here, because it's a dialogue with institutions and other entities. Then we have the speakers. We have Professor Bernd Stahl, and he is Professor of Critical Research and Technology and Director of the Center for Computing and Social Responsibility at the Monfort University, and he also represents here a sister project, a Sherpa project, dealing with ethics and human rights impact of smart information systems, SIS. Then we have Aliuska Duardo. She's a postdoc fellow researcher at the Department of Public Law, in chair of Law and Human Genome at the Basque Country University in Bilbao, and she is also from the coordinating entity, which is University of Basque Country, of this project, PANELFIT project. Then we have Zuzanna Warso. She's an advocate, and she works as a researcher at the Helsinki Foundation for Human Rights. She also represents here another sister project, which is Sienna project, and this project addresses ethical issues in the 3 new and emerging technology areas of human genomics, human enhancement, and human-machine interaction. Then we have Nicola Orlandi, who's a lawyer and data protection officer of Novartis in Switzerland. So we have this very diverse composition of panel, and we hope that all these points on the table will be developed at the best. Thank you.
Good morning, everyone. Thanks for joining us on this session where we are going to discuss actually the interplay between ethics, human rights, and data protection in the research context. And to make it more interesting, we added health and the AI. So what we are witnessing every day is that private and public actors are finding more and more innovative ways of processing health data and using health data for different purposes, to provide us with new diagnostic tools, to provide us with new treatment or targeted services, and to understand health-related behavior. In many cases, however, the data that is used is not consistent really with the initial patient's consent or data subject consent. It may not be foreseen the purpose of the data processing. Normally, it can happen, especially in big data research. You can't foresee what you are going to use this data for. And then it may not comply with the expectations of the data subject and the initial purposes to which the data is given. And to make the situation even more complex and challenging, we are living in an era of Internet of Things and a lot of smart devices that are collecting health-related data, and they are sending it somewhere. Do we know where, who uses it, and how this data is used? So the question to the panel today will be the challenge how to ensure the balance between protecting fundamental human rights and the need for advancement of medical research, which aims in general to ensure the good of the humanity, and it's good for the mankind. And can we ensure actually fairness, transparency, and in the data processing and accountability? So the first question will go to Bernd. Knowing that we have different legal bases for data processing, health-related data processing that are not necessary consent, can we justify actually research, health-related research that involves research participants who are unaware that they are actually participating in health-related research? How can we balance the need to do so? And can we always say that public interest is good enough to justify because we want to achieve something for the well-being of the human mankind? What do you think?
Okay, can you hear me? Yeah. Okay, so my response comes firstly from the perspective of the Sherpa project, which is one of the sister projects of PANELFIT, but it's also very much influenced and informed by my work in the Human Brain Project. Now, the Human Brain Project, if you haven't heard of it, is one of those big EU flagship projects that is currently aiming to develop a ICT infrastructure for neuroscience. And in that project, we have tons of data, we have tons of ways of processing data, but I would like to pick out one particular aspect, which is what we call the medical informatics platform. So what the medical informatics platform is doing is precisely what Albena was just talking about, namely it's using patient data for research purposes. Now, we've been, and this has been going on for years, so we've been doing this for about 5 years now. At the moment, the way this is implemented is that the data is de-identified in the first instance, then it's anonymized on top of that, then it's aggregated, and we also have informed consent. So we have hopefully everything we can possibly do to get it right. But there are always questions about, can we use it in different ways? Can we extend it? Can we use the data for other purposes? Can we use it, combine it with other data sources, and so on? And that's, I think, where the question of balancing comes in, which is partly a legal question, but I think it's also an ethical question. On what grounds would we say that the public interest, the question of general health improvement, possibly economic incentives, that these outweigh interests in terms of data protection and protecting the individual? So my main point, the one that I would like to make in this panel, is that what exacerbates this question is that both the benefits and the costs are fundamentally uncertain. So in the previous panel, you may have heard that there are promises that in the US alone, AI in healthcare is going to shave about $300 billion, if I remember this correctly, from the overall healthcare bill. Now, does anybody believe that? Do we have any reason to believe that that's true? Well, maybe there are good reasons. I'm not aware of them. The point I'm making is that these are projections which are fundamentally uncertain. They may be made with good faith, and they may be based on good data, but whether it's going to happen, we don't know. So that's in terms of economic incentives or in economic consequences. But I think we have the same uncertainties around the actual health benefits. Now, it seems to be reasonable to assume that better understanding data, having more data, being able to analyze more data, will lead to better insights into diseases, into possible diagnosis, into possible treatments. But there's no guarantee that that's true. It may happen in some cases, it may not happen in other cases. So there's a lot of uncertainty around the benefits. Similarly, though, there's, as far as I can see, there's a very high level of uncertainties around the costs and the possible damages. So what are the damages that are going to occur? Now, who is going to be the one who will be bearing the costs? So if privacy violations occur, what's that actually going to mean? Now, if a whole bunch of medical data goes out into the open, who's going to benefit from that and who is going to have to pay the cost? Clearly, it's very easy to see that there will be damages. Now, if somebody gets health data, that may be misused for all sorts of purposes, but it's unclear how that would happen, how that will happen, and who will be the one bearing the brunt of it. So, and that, I think, and that's really my main point, that's what we're struggling with in the Human Brain Project, but I think that's also an underlying concern in the entire AI, big data, and health context, is that both the benefits and the costs are uncertain, which raises the question of how can we balance them. And instead of trying to give an answer to this, I'll just leave the question here because I don't have a good answer to it.
Thank you very much, Bernd. In this situation of uncertainty, we have to protect the human rights because GDPR is based on human rights concept. So how can we ensure, Zuzanna, that the interference in the right to privacy of the individuals is actually proportionate, given that these individuals may not know and may have not given their informed consent to participate in the research? Any guidances? Any answers?
Thank you, Albena. Thank you for the invitation. I'm really happy to be here. It was already mentioned that I'm part of the Siena project. This is also a Horizon 2020 research project. And in the Siena project, we're mainly, among others, as lawyers, looking at the human rights challenges brought up by different technologies. And we're trying to figure out whether the existing human rights protection standards provide some guidance on those new challenges, believing that there's no point of reinventing the wheel and that there might be some good ideas over there, even though they were not established with those technologies in mind. But let's remember that the European Convention of Human Rights is supposed to be a living instrument, so it should be able to accommodate different new challenges. So besides the fact that human rights simply matter and that we should protect them, there's another reason why framing those issues that are talked about here in terms of human rights is quite important. It's simply because those cost-benefit choices and the trade-offs that are being made in the governance of new technologies may and probably will at some point be assessed from the point of view of human rights. And I think in 2013, René von Schomburg published in his book examples of innovation failures. And some of those failures were exactly due to the fact that the so-called normative anchor points were neglected. And recently, Daniel Rugia, in his book, mentioned, in this very context, mentioned stem cell research in Europe, where that faced serious economic consequences because of the, in this case, Brussels judgment of the Court of Justice. So, in fact, I would like to talk about briefly two judgments of the European Court of Human Rights, and I specifically want to mention judgments and not soft law instruments, because I think it's also important to know that these are legally binding rules. These judgments are not were not created, and they do not refer to AI or big data in any way, but they provide some guidance on how to address those questions. So the first case I want to briefly mention is a case that was against Latvia in 2014, and then in this case the court was faced with the question whether collection of personal medical data by a state agency without the consent of the person who filed the complaint violated her right to respect for her private life. And the state agency collected this data for the purpose of court proceedings that were ongoing at this stage. And in this case, the European Court of Human Rights looked at the law, whether the law guarantees the protection of privacy of the person who filed the complaint. So this is one of those cases where the court actually assesses the law, and I think this is the tendency that that is more and more, that is stronger, especially in cases that have to do with surveillance, for example, but also processing of personal data, where what matters is actually the quality of the law, whether the domestic law protects the interests of the individual. And having in mind what was said in the previous panel, where the research should be based on domestic law and should have some serious and nuanced legal basis, I think this is very important. So, just briefly, the court looked at the law and said that the competence of the state agency that collected the data and that processed the data was very broad. So it wasn't nuanced enough, and the scope of information that they could collect was so broad that it wasn't possible to assess whether it actually serves the purpose for which it was collected. Of course, this becomes more and more problematic when we talk about research, because it's sometimes difficult to assess and to say what kind of scope of information and of data needs to be collected in order to pursue the aim. However, there needs to be at least some reasoning behind this to be able to show that the law is not just a blanket law that allows everything to take place without any justification or any reasoning. So in this case, the court assessed the law, and I think the test that the court applies in this kind of cases is very important for the national legislators when they establish the law for research, and not to rely too heavily on this broad concept that freedom of research should allow gathering of data, because this simply won't pass when the case reaches the court. And another case I want to mention has to do with uncertainty, and there's not so much case law on handling risk issued by the European Court of Human Rights, and particularly very few cases concern technology itself. However, and interestingly, court quite rarely mentions precautionary principle, only on some occasions. But the case I want to bring your attention to was against Norway, and it was Vilnius against Norway, and it concerned divers who worked for the petrol industry. And after several years, it turned out that they contracted health problems because of the use of inadequate decompression tables. And in this case, it was a question of positive obligations of the state, whether the state took measures to implement laws that would protect the rights of the individual in cases where private entities were involved. And the court said that particularly in the face of uncertainty, it's very important to be cautious, and it was mentioned also during the last panel that when the state authorizes certain activities, be it commercial activities or be it research, it has to take extra measures to ensure that the rights are protected, and it shouldn't give too much leeway, especially to private entities, so that their commercial interest may be protected. There has to be an authorization process, and there has to be transparency. And as I said, in face of uncertainty, scientific uncertainty, this precaution has to be foregrounded in any case. So that's all for now, and I can talk more about the ECHR and the tests and the proportionality, but maybe later.
Thank you. And Staying with human rights, Aliuska, do you think that we can actually enforce the rights to access or any other data subject right when we don't know that we are data subjects? And what about incidental findings policy? The right to know or the right not to know? Can we actually exercise them in the area of big data and AI?
That's are many questions and many good questions. Thank you. First of all, thank you, Albena and Gianclaudio, for letting me be part of this initiative. Well, I want to take advantage of my 8 minutes of intervention to share some doubts and concerns which face the processing of health-related data both in medical research and in clinical practice. And I will answer your question if I can, whether I can. Okay, I'm going to raise my doubts and I will to be giving my conclusions at the same time, whether I have any, because I'm afraid I'm bringing more questions than answers. No? Well, the first question is deal with the very concept of health data. When we talk about health data, as we all know, the DPIA qualifies them as sensitive data and gives them enhancement protection. But what meant by health data? What happened to the data that are not directly health data, but which are related to it? No? Scientific studies give this type of data more and more relevance. We are talking about lifestyles, professions, leisure. This data is very relevant when we are talking about the use of artificial intelligence or big data tools. No? So, are these health data? Do they deserve the higher protection that the regulation confers? My answer, well, yes, I think these are data, health data, and I believe that the legal protection of data related to health may extend to any data with relevance to health. What I propose is the legal assimilation of personal data concerning health and data indirectly related to it when this is circumstantial data are permanently or temporarily linked to health or are used for purposes or context directly related to health. For me, the key is the context in which the data is used. No? So, this is the first question. My second question is when we talk about the massive processing of individual data or large scale data of all kinds, including this circumstantial information of which I have spoken, we use the use of big data and artificial intelligence tool is very, very relevant for the advantage. Everybody knows the advantage and the advantage offered by these tools in research, but also in terms of improvement of the management of healthcare systems. No? I will not talk about the advantage, but just the challenges these tools faces, the legal and ethical challenge, because these tools have the ability to obtain personal information that has not been provided by the interested party. That's the point you was talking about. They pose the risk to re-identification of anonymized or pseudo-anonymized data. They can promote a tendency of automatism in health decision making. Also increase the risk of classifying people in groups or subgroups of according to their personal profiles, things that the regulation is trying to avoid. Okay. I will focus in the first question. So, the data that is not directly provided by the subject of the research or by a patient. Okay. These rights are complicated to balance and ensure when in the framework of scientific research. How much more difficult is this when we are talking about that the person didn't know that this data exists, because this data is inferred by intelligence, artificial intelligence, or big data tools, no? In this sense, the use of big data tools and artificial intelligence raises new perspective for the exercise of autonomy by patients or the subject of research. And these new ways of revealing the data have to make characteristics from my point of view. First, it not depend of the will of the interest party to generate this personal data, not depend on his will. Second, the law cannot foresee the nature of this data so easily, and depending on it, establish their specific legal regimen is very difficult. How to guarantee this right on the right of the interest party in this case? Well, I'm not sure how. Maybe to communicating to the research subjects research results, which may concern of interest of or interest them. Although this suppose an extra load for the researchers. Researchers are angry right now with the Gdpr. Mine is Gdpr is an obstacle for researchers. But my second conclusion, however, is that the autonomy of the subject could be expressed once the existence of such data is known. And from that moment, take the decisions he considers appropriate without prejudice of limitations or other questions provided by the law. That's my conclusion regarding this part. First question, Albena. It is possible to enforce the right to access or any other data subject right in the era of big data and artificial intelligence, when in many cases the data subjects are unaware they are actually part of the research project. That's very, very difficult. No? We know all the Gdpr sections regarding research. In Spain, for example, the biomedical research law authorizes, with exceptional character, that is true, but authorizes the treatment of coded or identified biological sample for the purpose of biomedical research without the consent of the source subject, when the obtaining of such consent is not possible or represents an unreasonable effort. So we are talking about research without the consent of the data subject. I think it's a similar case that we have analyzed before, and the subject must take the control of their data and the exercise of all his rights as soon as he knows their existence. And the last question, well, this is harder and harder every time. Okay, what about unexpected or incidental findings, such as deleterious genes in both in research and in clinical practice? In addition, what about the subject right not to know in the context of incidental finding? And I will go even further. What happens with the biological family when the right not to know has been exercised by the patient or subject of a research? Okay. This is every time more complicated. It is possible to make this right compatible with the interest of the biological family. According to the regulation, there is the right to know our information in the area that we are discussing can be, for example, information on the result of genetic analysis. In the Spanish case, for example, Article 49 of the Biomedical Research Law provides that the source subject will be informed of the genetic data that are obtained from the genetic analysis according to the terms in which he expressed his will. His will can be not to know the result of a medical test. Okay? And this expression of will, in relation to the communication of the results, must be expressed at the moment of granting the consent of the genetic analysis. informed consent, once again, informed consent. Therefore, physicians or in the case researchers should ask in advance about what the decision is, explaining the possible consequences. It should be noted, depending on the type of analysis to be performed, the possibilities or certainty that they will find information unrelated to the pathology under treatment and its potential significance for the life in the subject and of their relative. Okay. So, seeking the Spanish law, we find a legal duty for physicians to act when they find unexpected findings, and even when the person have expresses the right or the will to not know about the analysis, there exists a duty to act when they find some unexpected finding that can affect the family and can affect the life of the patient itself. And it well in a research context. They are a duty. So the right to not know break down in this constant, in this context. Okay. Well, it's okay.
So we open down for more questions.
Yes, but I think it's very important to hear the business perspective on how to achieve this balance between the public interest and the private interest and the individual interest in the situation of uncertainty that Bernd mentioned. Are there any safeguards? Shall we establish some boundaries or some framework? What is your point of view, Nicola?
Yes, thank you, Albena. Thanks, Gianclaudio. I mean, yes, sure, we'll have to work on balance. We'll have to work on measures, on safeguards. I think what we are facing in these days after GDPR, I mean, it's a huge change. I mean, in terms of approaching scientific research. And since scientific research is clearly mentioned in the GDPR as one of the areas with a dedicated path, really, for managing research and managing and processing really data on this for this purpose. So if we say we want to use data, we want to do scientific research, I don't think it's right to say without consent. I mean, I think it's better to say we have alternative to consent, provided that we have clear measures and safeguards around the data and around the way data is processed. I mean, and since without consent does not mean that is by default done against the patient. Without consent means, in my view, that we have alternative legal grounds supported by clear balances and clear way to manage the data. And as we discussed in the previous panel, this cannot be done really by industry itself. So if there is a possibility to proceed with the further use of data according to the Article 5, stating that it's not incompatible for scientific research, plus the measures under Article 89, it's clear that this has to be done in line with and supported, really not in line, but must be supported by a union or member state law. So defining and supporting both, I mean the safeguards, creating new safeguards or supporting the safeguards in the meantime, maybe defined also by the industry. So, and this is valid for doing scientific research. This is valid when we approach a new way to use data in combination by themselves, so big data, or when we want to develop artificial intelligence. So what data we have to use in order to train the algorithm, in order to feed the algorithm. So, and this is where we need to define boundaries. We need to define exactly what does mean in terms of data, also in terms of what kind of data. So here for scientific research, from a company perspective, we are not talking about individual level data in clear, we're talking about already key coded data. And then what are the further measures to be taken in order to to further use this data and to protect this data also when maybe recombining with other data coming from other sources that is not does not have the same level of codification, let's say. So, and this is where it's important to define a language in data. So, what data we need to use? What data? What is the level of data? Fully anonymized, anonymized with a risk-based approach, as we discussed this morning or yesterday in another panel. We can use pseudonymized data, having in mind all the safeguards we need in order to do that, and then maybe even consent as a safeguard can be considered, but it's not really the legal ground yet. So I think this is where we have to build. So, but I think it's important to create, not only from an industry perspective, but more in general, a new language. Normally, I'm using in my discussion with my colleagues to mention the fact that we are obviously making reference to the GCP. GCP were created, I don't remember exactly when, but I mean some time ago, and they are intended to govern the management of clinical trials. So step by step, probably we have to work on something similar with a different name, obviously, when dealing with scientific research and further research of data that is not GCP. I don't know, how to call it, but it's something that will support the steps. And then in addition to that, that is more from a technical, let's say, operational point of view, we can work on some internal and even external governance when dealing with data, meaning ethical analysis from a company perspective can be done in terms of evaluation of the meaning of scientific research. This will mean to change in some way the process is managed internally. This will mean to change the governance, but it can be a way to also manage the principle of fairness and transparency. What does it mean to have the same level from an external point of view? So to give also to the ethics committee maybe a different way of looking at the scientific research, since now I think we all have to raise our awareness about how to approach the research also from a privacy perspective according to the new GDPR. So I think this is what we have to create in terms of balances and measures. We can discuss about technical safeguards, segregation, confidentiality. We can discuss about creating different units working with data for the initial scientific research and then for the further use. This is something we can discuss. What is important is that we align, we all agree, in the creation of a common path that will help to manage both the privacy piece, the ethical piece. They are strictly linked, but they cannot, the GDPR per se is not solving the ethical piece. So this is where I think we need to work, since, again, just to close, scientific research is clearly recognized in the GDPR as one of the area crucial from a privacy point of view, in this case for the European citizens, since otherwise, there would not have been this clear article and recitals mentioning scientific research and the possibility to perform scientific research and further use data for scientific research. Thank you.
Yeah, so thank you very much for this first round of interventions of our speakers. So many issues on the table. So yeah, we see that first of all, conflict between the ethical approach, which is, as we were saying before, when we are with medical clinical trials data, we are always based on consent of the patient, the consent of the person, but then we have other legal bases on the GDPR. And even in that case, as Albena was saying, there is often unawareness. Because actually, yeah, we have always a right to be informed, but there are some exemptions to the duty to inform under Article 13 and 14. So we have all these conflicts between what is apparently very much regulated in GDPR. For example, when you have sensitive data, you're obliged to do a data protection impact assessment, or you have more chances that you are obliged to do that. Even Article 22, automated decision making with sensitive data data, they should have specific measures of protection. In addition, you have to have a DPO, and so this is a great, a great opportunity for protection. But for the other side, we have difficulty to inform all patients. And what Aliuska was saying also, that there are other people, there are relatives whose indirectly personal data are there. The secondary data subjects, which is a great problem in terms of the right not to know. We are always talking about right to information, but there is the right not to know my destiny. So all these problems are on the table. I hope there will be some other provocation and comments to our speakers from you. Someone want to do some question, please? There is a microphone there. You can briefly then everyone present yourself and then introduce yourself.
Robin Pierce from Tilburg Law School. I wanted to ask you, Bernd, a question regarding your observation, which I share, about the hype of AI and that, that it was the speculation that it would cut healthcare costs by 3 trillion, I think was the figure. And you said you don't have the answer, and you wonder how this, can constitute a public benefit. There's uncertainty about how it can constitute, how and whether, to what extent it can constitute a public benefit. But my question is, you said you don't have the answer, and you are anxious to hear what other people have to say. But I'm wondering, is this really an answerable question? Scientific research by nature is we don't know what we will find or what the outcome will be. So it requires that we come up with a construct of some sort. And I was wondering if you had any indication of what those parameters might be, given the sort of open-ended nature of science by nature.
Okay, so that's a very difficult question to answer. I think that the uncertainty, the main point I was trying to make is that we have those mutual uncertainties. It's not just one thing we don't know, but we have to make a decision. We always have to make decisions under uncertainty, yes. No, and we don't know what the outcomes of a scientific process are. Fully agree with that. At the same time, though, we have ways of assessing, measuring, or predicting outcomes, for example, which are built into the entire scientific process, proposal writing, evaluation. You have to say something about what you expect to come out of it. That has to be reasonable enough to convince your peers and then get funded. So I think we have mechanisms to do that. Similarly, we've heard about the mechanisms which we can put in place to safeguard particular interests, where we can have technical, social, and other mechanisms. So maybe that overall certainty can be reduced to a certain degree. My main concern is that at the moment, both sides are completely blown out of proportion. So I absolutely do not believe that integrating a new technology into healthcare is going to make it cheaper. I would be extremely surprised if that were true. I can, however, see the argument that it will actually lead to insights which may be morally beneficial in the sense that they can improve health. So I think my plea here would be to critically assess the claims that we are making and on which these decisions are made, to not just simply believe what McKinsey tells us or whoever else tells us, but to actually try to be more specific in assessing and evaluating and balancing those different claims. And I think that's part of what the scientific process should do, but I think at the moment, in particular with regards to AI, the hype is so great that it's very difficult to be reasonable about it.
I think there were other questions, yeah? Yeah, please?
Yeah, I'd just like to comment on the parameters that are being used for the numbers.
Maybe they cannot hear.
It's not working.
Okay.
Yeah.
Just wanted to comment on Robin's observation and Bernard's regarding the 300 billion number that I used during my presentation on the last panel. They're trying to come up with some statistics to back that up, so it isn't just a pie-in-the-sky number. And some of the things that they've used include the costs of adverse drug experiences, which they estimate to be about $4.7 billion per year. Of course, an a clinical trial setting, it's very controlled, and the individuals are only on the compound medication generally and not on other drugs that they may take in real life. So once the drug is approved, you see a lot more side effects. And if some of this could be determined by big data and save the medical costs associated with that and the health problems associated with it, then that's one of the benefits. Another is that cancer therapies often fail, supposedly fail in up to 80% of the patients. So if you're able to detect which ones work in which particular patient, you're saving all of that money and expense. And some of the treatments are $40,000 per treatment in the U.S. So it's become very big business. As you know, from Novartis, they have a very big oncology department. And so some of these things. And then similarly with screening, breast cancer screening, women typically don't really like going for mammographies, and then you're exposed to extra radiation and so forth. So if you could tell in advance which patients are most likely, based upon genetics or other factors, and really need that testing, then you could save the money and excessive costs and MRIs and so forth for the other women. So it's these types of factors that they're looking at, and another main one is enrollment in clinical trials. It's very difficult to get patients, and you have to get patent protection up front, so every day of patent life costs pharmaceutical companies a great deal of money, and so this is another huge cost, and the same with medical devices. If you can tell, for instance, that doctors aren't using the medical device properly or not inserting it properly into the patient, you can save a lot of costs and adverse effects coming from that. And so that's another benefit in the healthcare context.
Does someone want to comment on this? Yeah.
It's only we heard a lot of ifs, and I think that this is what Bernd referred to. Please.
Okay. Just to add something on what you said, I think that the issue of benefits, societal benefits, individual benefits, is problematic. GDPR does not protect just individual rights, but also free flow of information and other kind of objectives. I think that in particular, like in ethics, it's not just individual based, but it's also societal based. So it's something that, discussions that are being developed. So moving from the individual level to the community level, it's very much problematic, I think. But there is something that you were referring to, positive effects. No? For example, breast cancer predictions, etc. In that case, it's an automated decision sometimes. So there are these predictive algorithms. And in the GDPR, you have Article 22 that says basically that a significant effect, legal or similarly significant effect, should be prohibited if they're based on automated decisions, unless there are some safeguards. And there are some member states who said that just negative decisions, not positive decisions, would be prohibited. In that case, your example is very much interesting because it's positive the effect that I am producing, and in that case, there should be not such, not paternalistic, but like protectionist impact. So it's very much a discussion that needs to be developed, I think. Yeah. So next question.
So my name is Shaban Meza. I'm a DPO at the Technical University, which means no law. But we have a lot of people working in research project because doctors, physicians ask technical support. And my questions from this point of view consider also the GDPR. There is a mechanism there that's have hardly mentioned here, the code of conduct, which can be approached sectorial for research, for instance, and even another sectorial for health data. So what's the panel opinion of using this in an approach to unify or at least give some operational instruction to which university or, let's say, reputable research institutes could adhere to in order to overcome the fragmentation that exists nowadays besides Europe? And then another question would be, if we speak a lot about the ethics involved and so on, will that affect the competitiveness of here? Because from my point of view, it's easy then, okay, if you have problems with patients here in Europe, I will just partner with a research something in Turkey, Iran, China, Africa, which is, they have laws, okay, of course, but maybe they are not that restrictive. I put a server there, I do my processing there on their patients. Yes, it's okay, I have some results, and then I can come here in Europe and then I say, or in the US or in other ways, say, I have reasonable expectation that my research is good enough, and now we can make trials here. So these are my two questions: competitiveness and code of conduct.
Maybe Nicola wants to.
Yep. Yes. First, to the code of conduct. I mean, for sure, it's one of the possibility to. When I was mentioning before the creation of a new governance of a new language when dealing with health data for research, code of conduct can be one of the outcome. For sure, is related to a specific area, is related to a specific sector, and maybe even companies in some cases can be a way. The alternative is to have, as I've heard this morning, I mean, more detailed and more specific regulation, applying finally the principle in the GDPR, especially really with reference to scientific research, respecting the spirit of the of the regulation, and implementing something that will help to manage taking decision or applying the safeguards or something like that. So it's something that probably is really what is under discussion. So what is the best way to implement something, and going to your second question, that will help to present Europe as a whole as something that is not creating barriers to the scientific research, but is creating a framework that can be safe for scientific research. I think this is what we all aim for. But I know, I mean, there is this question pending, obviously, but I think the answer is related also to the way we will implement the GDPR in a way that will be, I don't want to say easy, but will be clear how to take decision and to move forward.
I think the implementation of codes of conduct is unavoidable. I mean, this is one of the instruments to balance and to figure out those precise rules, and it's happening in other areas. I'm talking from the perspective of human rights protection. If you assess a case and are supposed to say if the infringement or limitation of a right was lawful, the code of conduct is, for example, established by journalists in freedom of speech cases. It is taken into consideration where the court assesses the proportionality. So, and also with the new technologies, I think this whole idea of co-regulation and self-regulation. I mean, I'm a lawyer, right? So I'm not a very big fan of professional codes and self-regulation, but I think this is the way to go. And as far as the economic interests are concerned, I mean, this is the argument that's being raised again and again, right? That we in Europe, because of our high ethical values, are way behind other parts of the world, but I mean, that's the choice we've made. So, and there are some strict rules about third country involvement in trials. So I don't think that's as easy as you painted it.
Just comment on ethics dumping and competitiveness, because I think the codes there. We do believe, and there are studies showing that if we embed our values in the technology, that will actually increase the competitiveness of European companies. Europe is based on values, and I think that this is one of our strong advantages. In December, European Commission published its action plan on AI, and implementing ethics by design principle for all calls funded by European Commission is one of the commitments. But what I think is even and equally important is the ethics guidelines that are currently drafted by high-level group on artificial intelligence, and business interests are heavily represented in the group. So I'm not afraid that we will diminish our competitiveness by issuing these guidelines. And it is a firm belief of both the group and the Commission, that we have to actually work with other international organizations of collaborating on having a common ethics standards as for design of AI systems, because we can't just limit it to Europe. Then we will have, obviously, first we are collaborating, and secondly, we can't limit AI to the boundaries of our continent. So I think that this is the way forward. I mean, we have to be able to predict the anticipated effects of the technology, embed ethics by design in all the products that we are building, and try to work towards international standards on ethics by design in AI. And I think it is possible. It certainly won't be very easy, but if we manage to achieve a climate accord, with some difficulties in it, but still most of the world agrees with it, I think that this is the way forward towards ethics by design for AI as well.
Okay, maybe there are some other questions. I saw a hand. There are, can you raise your hand? We collect them together, so we have like 8 minutes and we can reply to. Okay, so one there and one there. Thank you.
Hi, I have a question about very narrow case when personal data could be used in the sphere of medicine. It's a question about the development of autonomous surgical robots, for example, where you need to use a sensor during the operation in order to train the AI of which actions should be performed in order to operate during a specific type of surgery. How do you estimate whether existing legislation is preventing the development of this technology, and if yes, why and what should be changed? And if it's not preventing, maybe the development of this technology based on the personal data is not ethical, or whether it's ethical in your opinion. And the last part is who should be responsible for the selection of data about such type of operations, who is going to be used to train the system, and whose data is not going to be used to train the system, and what if the data which was used to train the system is leading to the system malfunctioning afterwards, if it was selected in an unprofessional and improper manner? Thank you.
So there was another question also?
Make it easy. Does the panel think there could be a solution to both privacy and the problems of bias and AI by looking at privacy preserving techniques in data? So do you see any hope for example, synthetic data sets and development of training of AI on synthetic data sets, which could be a potential solution to both?
If there is one more, okay, so we go to the answers. Or maybe Nicola wanted to say something.
Yes. On the first question, I mean, it's not easy. It's a very specific case. I mean, but I think it touched really the point about how to create a system, a robot in this case, that will have to be trained using personal data in order to create a sort of automated approach to do some surgeries. Here, I think we are moving to the discussion about how to create artificial intelligence, how to define the algorithm behind, I mean, the robot. So what is the level of data we need? And then I think I can mix the two, combine the two questions really, since I think it's important to from a technical point of view, more from than a privacy in this case, to understand exactly what data is needed in the definition. And then I'm not an expert from a technical point of view, what data is needed in order to feed and train the algorithms. So since, especially when we do surgeries, but it's valid in general, I think it's important to to have some quality, reliability of data in order to touch exactly the area or to manage exactly the point we have to consider, and or if we have to predict diseases or to analyze some patterns in order to see if there is a risk or not to develop a specific disease. It's important to have quality and reliability of data to define the system in a way that is reliable from a scientific point of view, or from a technical if you have to do surgery. Then it's important to see what level of data we need in order to do that. And if we can use the individual level data, and if we have to use individual level data, then obviously we have to go through a specific entry point in terms of legal ground with the data subject. If we can use anonymized data or even synthetic data, so honestly I cannot tell you about the reliability in terms of quality of this data, but why not? I mean, if is but again, it's important to be sure that this new hybrid data set, synthetic data set, has the same value in terms of outcome of the real data, even anonymized or pseudonymized, but coming from the reality. So I think this is something that is mixing technical piece with the privacy point in terms of data. And for sure, I think if we are talking about a synthetic data set to be applied, training the algorithm to be applied on the humans, obviously there is also maybe an ethical problem to be discussed.
Other reactions? Yeah?
Just very briefly, thank you for the last question. We talk a lot about privacy and data protection, but I think actually the bias is the main human rights challenge when it comes to these issues. And again, I don't know how to, I'm not a technical person, so, but I am a believer in synthetic data in order that could accommodate and alleviate some of the biases that are here, and we know that there has been bias, gender bias against women in the clinical trials, and so if we imagine that that's going to be extrapolated onto AI and algorithms, I think there's a big risk there. So we need to bear that in mind first, and then maybe the use of synthetic data would be some solution.
Yeah, and just one point on robots that are trained through surgical operation. I think that, as Nicola was saying, it's a problem of data minimization. Do we really need to? I mean, I am not from a technical point of view, but do we really need to store data of patients that are real-time operated, and so that the robot needs personal data? So maybe Article 89 on anonymization and pseudonymization when we do this kind of... This is related to research, of course, but maybe in that field it's easier to see how data minimization is relevant, also very much related to the point on synthetic data sets. So I will just leave the floor to the chair for some conclusionary remarks.
Yeah, it's difficult to conclude because I think now we have more questions than answers, which brings me back to ethics. I mean, we all know that the foundation of modern ethical principle came as an aftermath of the Second World War and the Nuremberg trial. So there, obviously, the protection of the individual interest became the ground for basing all the decisions. And then more and more I read different academic literature saying, wait, maybe we have to reevaluate this. Maybe now, given the new technological development, the public interest, we have to focus back on the public interest and somehow balance it with the rights of individuals, because giving priority to the rights of individuals, we kind of forgot the public interest. And it's a academic discussion that I see and treat more and more, which brings us back to the data protection, where we have consent or we are discussing legal basis for data processing, but then in medical research, immediately we clash with the concept, no human being should be involved in the research without his or her knowledge, and how to reconcile that. And I think it's very important, and I very much like what Nicola said, that we have to create a common path between ethics and data protection, and we need the uptake of the research community, and we need the collaboration of the data protection experts, the data scientists, and the ethicists in order to create the framework that will balance properly and create the right safeguards, and most importantly, create trust in science, because we need data for scientific purposes. Without data, we can hardly advance. But if people don't trust and don't give us their data, then it will be extremely difficult to justify, and it will just create more and more uncertainty as to what we are experiencing now. So I think the more we talk and the more data protection experts talk to scientific researchers and ethicists, the more we will advance in this discussion. Thank you very much for your attention.